so I call here. Okay, just making sure.
Good morning, this is Dalia Romero, Spanish interpreter on the line. Already sworn in, Your Honor.
All right, good morning, thank you. We have, I think we're ready to get going.
A moment, Your Honor. Allow me to connect to that podium, please.
Yes. Oh yeah, we do use the headset here. I forget, because downtown we don't.
Sí.
He can hear the interpreter.
All right, good morning, sir. Please tell me your name.
Buenos días. But
Buenos días. Sandro Carillo. Carillo.
Santo Canigro.
This is case number 2021 MM45580. Sir, you're here today charged with battery, domestic violence. I've reviewed the probable cause affidavit, and I do find there's probable cause for your arrest in this case. Is there a victim here on this case?
Not that I'm aware of, Your Honor.
Is that who? No, she's not coming in. All right. Sir, I'm going to appoint the public defender to represent you.
Okay.
Okay.
Does either side wish to be heard on bond or anything, any other matters?
Your Honor.
No? Public Defender's Office?
No, Your Honor.
All right. Sir, at this time, I'm going to give you a $500 bond. If you are able to bond out, you are ordered to maintain separate residences. You are not allowed to have any contact with the victim. Do you understand what no contact means?
Sí, estoy leyendo aquí que todas esas cosas.
Yes, I am reading it here. All of those things.
Right. No third-party contact, no electronic contact, no contact at all.
Okay. ¿Por cuánto tiempo?
Okay, for how long?
Until your attorney files a motion in front of the judge who's presiding over this case, you're not allowed to have any contact. So until a judge says you can have contact, you may not have contact. Do you understand?
Okay.
Okay.
Sir, do you live at this scene?
No.
Okay.
No.
All right. Is there anything else, counselors? Oh, you're not allowed to possess any firearms or ammunition or weapons of any kind.
In your order, can you advise him of his immigration detainer?
I did not realize there was an immigration detainer. All right, sir. It looks like you might have a detainer by immigration. Where do you see that,
No
counselor?
tengo.
I don't have one.
I don't have to. Hold on. Sorry. I give it back. Oh, there is a detainer right there. Immigration. Sir, you're being held, and I don't know at this time what will happen with that detainer. So I don't think you can bond out at this time. Do you understand?
Sí, pero yo no tengo orden de detención, de migración. No sé por qué me lo dice.
Yes, but I don't have a detained order from immigration. I don't know why you're telling me that.
I have a piece of paper that says there is a detainer hold on you at this time from immigration. So I'm just advising you that that's there. You won't be able to bond out until that hold is cleared. So talk to your attorney about that, okay?
¿Pero cuándo?
All right, thank you.
Green too?
Now I see where it is. Thank you. All right, good morning. Please tell me your name.
Juan José Vega Sánchez. Juan José Vega Sánchez.
Juan Jose Vega Sanchez.
All right, sir. You're here in case number 2021 MM464AO, charged with battery, domestic violence. I reviewed the probable cause affidavit. I do find probable cause in this case for your arrest. Is there a victim here? I don't see anyone. All right. Sir, you also have a hold from immigration.
Ok, ¿cómo entonces? Pero ¿me puedo conectar con alguien para avisarles o no?
Okay, well, can I connect with someone so that I can let them know?
I'm sorry, can you what?
¿Sí me puedo comunicar con mi abogado de inmigración o no?
Can I communicate with my attorney for immigration or not?
Yes, and I'm going to appoint the public defender to represent you in this case, so you can also communicate with that attorney. I'm going to
Okay.
give you a $500 bond. If you're able to bond out, you have to maintain separate residences. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Sí, pero para sacar como ropa y eso, ¿puedo ir a la casa o no?
Yes, but to remove my clothes and things like that, can I go back to the house?
You may return one time with law enforcement, only with law enforcement.
Ok, está bien, sí, entonces ahorita no hay que pagar los 500 o hasta que vean qué es lo que va a pasar o se puede pagar los $500.
So right now, we cannot pay the 500 until we see what happens, or can
Right.
we go ahead and pay the 500?
You can, but I don't think you'll be released until the immigration hold is cleared. So ask both of your attorneys about that and see what they advise you to do. Sir, also while you're out on bond, you're not allowed to possess any firearms or ammunition. Do you understand?
Ok, bueno, a la mano no tengo el número de mi abogado, no sé si lo podría conseguir en por algún medio, no sé.
Right now, I don't have my attorney's number. I don't know if I would be able to get that somehow here.
Madam Interpreter, the phone number, can you tell him the phone number is listed on the green sheet we've given him for the Public Defender's Office? If he contacts that number, we'll be able to get him in contact with an immigration attorney.
All right, good luck, sir.
Ok, yo tengo un abogado de inmigración que ya me habían aprobado, pero no sé si tengo que hablar con mi abogado que ya tengo o no.
I already have an immigration attorney that it was approved. I don't know if I have to talk to the other attorney as well.
So the other attorney is the public defender who is representing you in the criminal charges against you. That's different from your immigration attorney.
Ok, está bien.
Okay, very well.
All right, good luck, sir.
Gracias.
Thank you.
Next.
This is Ms. Lott, Your Honor.
I don't believe she needs a Spanish interpreter, is that correct?
She does not.
Madam Interpreter, I just need to do one case, and then I still have a couple cases for you.
Not a problem, Your Honor.
Oh, I don't? Oh, that's all I have. Oh, thank you.
You're welcome. Thank you.
Have a nice day. All right. This is Billy Joe Lott. Ma'am, you're here in case number 2021 MM309AO. It looks like your charge is a violation of pretrial release conditions in a domestic violence case.
Yes.
Do you have an attorney representing you, ma'am?
Supposed to. That's what they gave to me in my room.
A public defender?
Yeah.
All right. If the public defender wasn't...
Stacy. Supposed to be Stacy.
Oh, it says that right
Yeah,
there.
Stacy.
Yes, you do have the Office of the Public Defender. They do represent you.
Yes, Your Honor. There's no offer in this case, so the defense will enter a plea of not guilty.
All right, ma'am. You're going to meet with your attorney about this, and then it'll be set in front of the judge who's actually hearing the case. And the date will be?
It's Division 50 pretrial conference, February 8th at 2
Yeah.
p.m. in 7C.
Oh, downtown?
Is there a bond?
Yes.
All right. All right, ma'am. So that's your next court date. Make sure you get in touch with your attorney. Good luck.
Yeah.
Sir, please tell me your name.
Cody Dalton Naaman, ma'am.
I don't have that. Tell me your name again.
They got it under Isaac Amon for some reason.
All right. I have two other people that are not
He
him.
was the add-on, Your Honor.
What's the case number?
It's underneath the gold form.
So this is case number 2020 CF 13769AO. You were here yesterday. So your name is Cody Aman or Isaac,
Yes, ma'am.
also known as. All right, you were charged with burglary of a conveyance and petty theft.
Burglary of conveyance.
Yes, that looks like that's what the charge is. And it looks like you might have been placed on pretrial release, but you don't qualify.
Oh, those are old
I don't
charges.
have, did Judge Bain
Those are
find
old charges.
probable cause? I don't have a PC for this.
Those are old charges.
Okay. Okay.
And based on history of all the name he gave, it showed me that.
But now we know he does.
Yeah, now we know he does. So that's why we brought him. He already ROR him on his petty theft case, which came in for yesterday.
Okay.
So once he was fingerprinted, his real identity came in. And that's where we found him out.
Those are
All
old
right,
charges.
so then what do we do with him today?
It depends if you want to take an action on his bag. Based on it wasn't shown yesterday, because he wasn't fingerprinted.
I just don't feel like I have enough information.
Those are old charges, ma'am.
Okay, hold on one
Yes-
second.
yes,
sir.
ma'am,
I'm
I
trying to sort this
apologize.
out.
The old case number. I can pull up the court number from yesterday.
But what I'm trying to figure out, I don't understand what we have to do with him today.
Oh.
If Judge Bain found probable cause for the petty theft but ROR'd him,
Based on
They didn't have that
the
yesterday.
name, the wrong name he gave us, he gave us a false name.
okay,
So it showed like he didn't.
nonetheless, Judge Bain found probable cause for the only charge that's pending, or is there another charge?
He came in on petty theft under the name Isaac.
Okay,
And on his face sheet, he didn't have any criminal history. But he never.
Right, I get all
came
that.
to court. Okay, yeah. So Judge Bain said, there's no CPRDC, he didn't come to court because he
Mental health issues.
or ROR. So he didn't qualify for mental health DTR, so we ROR him. Upon release, he was fingerprinted, and we had to run his criminal history again. And that's when we found out he's really Cody Amon.
Okay, but is there another charge pending, other than the petty theft?
Just the out on bond, those charges are there, like out on bond.
So he's already out on bond.
Yeah, he's out on bond.
So the only issue before the court this morning is, do I want to change his ROR to a monetary bond?
Or if you want to revoke his out on bond.
Oh, because he got the new charge
Mhm.
while he was out on bond on this charge.
Mhm.
So this isn't, it's two different cases, that's what you were saying. The old cases, no, that's not it. Okay, that's the same case number. I'm super confused, you guys.
Okay, so the only thing that you're addressing is the FAD detainer. Judge Bain addressed his new charge yesterday, so they
But he
found-
didn't address this old case and whether he was going to revoke his bond.
He didn't know about it.
Ah.
Yeah, he didn't know.
I wasn't on bond.
Sorry. Now I get it. All right, sir. It looks like you saw Judge Bain yesterday for a new petty theft. And you are correct, the burglary of a conveyance and a petty theft is an old charge. You were out on bond on that case when you got the new petty theft charge.
I wasn't on bond when they ROR'd me. She got the charges thrown out on 33rd-day motion.
Who's she? Do you have the public defender?
Yes, ma'am.
All right. Can the public defender's office help me out with this?
Can I have the case number, Your Honor?
I think it's 2020 CF 13769AO. Well, that was confusing enough.
You said 1379?
69.
1369.
Today we do?
No, they did it, looks like yesterday. I'm printing it out now.
Okay.
Have an issue with the printer, but here's the 33-day motion. And it says the court takes no action, granted 12/18.
So December 18th.
It's 137.
It was not granted or denied
137.
because the state must have filed the charges.
There's something on 18th. Let me-
Is there an information in the case? Sorry.
What I looked at is that there is, no,
No, I don't see that information.
but on 12/18,
Oh, that one is granted.
and I think, so I guess they must
Why
have
are
said
there
it.
two?
Because maybe they said it again on the 21st because he was still in here, but the court took no action because he was already granted.
All right, hold on. Let me ask the state then. It doesn't look like in the, according to Odyssey, an information has been filed in this case. Can you help the court out with that?
Yeah, 1 second. Which case number specifically?
2020 CF 13769AO. It looks like from what I can see, he was released on his own recognizance in December, and no information or other charging document was filed.
Right, yeah, it appears on that case, an information has not been filed yet. So he should have been ROR 33rd day
He
on that
was.
one. Yeah.
All right, well then I'm gonna take no action on that case because the state hasn't filed a charging document. And it's now another month. So perhaps the state needs to make a decision.
We have 180 days.
Right.
175 days. So.
I know. All right, sir, I'm not gonna take any action on your out of bond case. All right, good luck, sir.
They told me.
You have to leave your mask on.
I apologize, ma'am. They said I was supposed to get out ROR yesterday. They said I was supposed to get out on this case yesterday. I really, ma'am, I just been trying to get by. I've been struggling, ma'am, and I'm trying to get help.
You're gonna get out today.
I understand.
I will get out
You-
today. All right,
Yes,
thank
that's
y'all
it.
so much.
Right,
That's it.
I'm not revoking any of your RORs.
All right, so I will get
So
out
now
today.
at this time, you will be released.
All right, thank you so much, ma'am.
All right, good luck, sir.
Thank you.
All right, I don't know who's next. Which one?
Good morning, Judge.
Good morning, sir. How are you today?
I'm fine. Harold Backus on behalf of Ms. Natalie Rivera. Your Honor, she's charged with, it's 2021 MM 21 AA.
Yes.
She's charged with domestic battery. We're asking for ROR, Judge.
All right, ma'am. As your attorney said, you're here charged with battery, domestic violence. I've reviewed the probable cause affidavit. I do find probable cause exists in this case for your arrest. Is there a victim here?
No, Your Honor.
No. All right. And Counselor, what would be the reason for the ROR?
Your Honor, Miss Rivera, it has ties. She's a registered nurse. Never had any prior criminal history at all. And she will attend every court hearing. There's absolutely, I believe, the facts as outlined in the report suggest that she was home in a house that she rented. She allowed the soon-to-be ex-husband to come back in, and he took her rental car, took the keys, held them in his pocket. She tried to retrieve them from the pocket, not from him. And then, from all reports, something ensued. If you look at the police report, it says that he kicked her, but the cop didn't see any marks on her. He didn't see any marks on him, but he arrested her. So there is indeed a wonderful case with regards to this.
All right. Does the state wish to be heard?
No, Your Honor.
I see that your client qualifies for pretrial release. I'm inclined to place her on pretrial release. Do you have any objection to that?
Judge, the issue is, as a registered nurse, if this goes before the licensing board, we're going to have, she may lose her formal, she has 3 little children. And I think that may interfere with her ability to continue working as a registered nurse.
Pretrial release? How?
So with pretrial release, you have to constantly call in, right? So therefore,
I don't think it's constant. I think it's once a week or...
Once every 2 weeks.
Once every 2 weeks? Okay, well then that's fine. PTR is fine, Your Honor.
All right. So, ma'am, what I'm going to do is place you on pretrial release. While on pretrial release, you're not allowed to have any contact with the victim. Based on what your attorney just told me, is this your residence?
Yes.
All right. I'm going to order that you maintain separate residences. If he doesn't live there, you can still live there. I understand it's your residence. But you can't have any contact with him. So if he comes to your residence, you can't talk to him, you can't let him in, you got to call the police, you can't have any contact with him. Do you understand?
Yes, ma'am.
No third-party contact, nothing.
Yes, ma'am.
All right.
And so that the court is aware, on Monday, the Monday prior to the incident, she had actually called the police to retrieve the same keys that because he took the rental car, went off with it, she called the police, and the police did nothing at that time.
Okay. Maintain contact with your attorney, ma'am. But at this time, I'll place you on pretrial release. Okay?
Oh, thank you, Your Honor. I've
Yes,
got
sir.
to be in juvenile court for a
Oh.
gotta run.
Well, good luck. I hope you get there in time. Thanks, Counselor.
I don't know. I don't know if I'll get there on time.
Thank you.
It's at 9:30 and I've got a Zoom class.
Right. Who's next? What's your name, sir?
Sorry, Attorney Michael Barber on behalf of Vincent Milione, Your Honor.
All right. You're here in case number...
It's 21 CF 732AO. I believe it's a third-degree felony, domestic violence, battery by strangulation, Your Honor.
Yes.
We'd be asking in a bond amount in accordance with the schedule. I believe it's anywhere from $1,000, $2,500. For a third-degree felony, we'd be asking for $1,000. And then we do have the victim here to give testimony, Your Honor, in regards to contact.
All right, ma'am. Please raise your right hand to be sworn. Please swear her in, please.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
I'm sorry, did you say yes?
Yes. Can you hear me?
Sorry, you have to speak really loudly. You have to leave the microphone, the mask on, but just get close to the microphone. You put your hand down.
Okay.
So that way we can hear what you're saying. Does the state wish to inquire? Or actually, Mr. Barber,
Yes,
go
I'll
ahead.
inquire, Your Honor. That's fine. Can you please state your name for the record?
My name's Alexis Chavez.
And how are you related to Mr. Vincent Milione?
He's my boyfriend.
And prior to this arrest, were you guys living together in one apartment?
Yes.
And are you in fear, Mr. Milioni?
No, I'm not.
And do you want to have contact with him?
Yes, I would like to have contact with him.
And would you like him to be able to return to the residence that you both share?
Yes, I'd like him to return to my apartment.
And in the future, if there was ever any incidents of violence, would you be willing to call 911?
Yes.
Thank you, Judge. No further questions.
All right, Steve?
No questions, Your Honor.
So, Your Honor, we'd be asking to have a no hostile contact order instead of a no contact, and to allow Mr. Milioni to return to their shared residence.
All right, sir. I did review the probable cause affidavit. There's probable cause for your arrest in this case. I'm going to set your bond at $2,500 on count 1 and $100 on count 2. If you bond out, sir, I'm going to order that at this time you must maintain a separate residence. Based on the testimony the court received this morning, I'll allow you to have peaceful contact, no hostile contact. Do you understand what that means?
Yes, Your Honor.
You cannot raise your voice. Nothing. Do you understand?
I understand, Your Honor.
But you also can't live there. I'm
understand.
ordering that you maintain a separate residence.
Yes, Your Honor.
So you're allowed to have contact with her, but you can't live there. Do you understand?
I understand.
All right, you're not allowed to possess any firearms or ammunition. And I don't recall, counsel, maybe for the state you can help me remember. Was there any alcohol or anything alleged in this incident?
Your Honor, I only have the confirmation of the arrest one. I don't actually have the affidavit.
All right. I don't see any allegations of that, so. I'm sorry. Do you have things there that you need to get out of that apartment?
No, Your Honor.
You don't? Okay, then no. There's no one-time return. You must maintain separate residences. You understand?
Yes, Your Honor.
All right, thank you.
Thank you very much, Your
Thank
Honor.
you,
Have a
Mr.
great
Robert.
day.
You as well.
I got to rush home because the workers working on my bathroom found a snake in there. I have to go get it out. Apparently, they're terrified of snakes.
Well, that sounds exciting.
Yeah, so that's for my morning story. Thank you.
All right, have a nice one. Sir, what's your name?
Devin Bishars.
Is that a niece? Oh, yeah, sorry. Okay, that's fine. I just want to know which pile I'm supposed to be looking at now. All right, sir.
Yes, sir.
You're here in case numbers 21 CF 77680, 21 MM 168E. Sir, I've reviewed both probable cause affidavits. I do find there was probable cause for your arrest in each case. I'm going to appoint the public defender to represent you. In 21 CF 77680, your bond will be $1,000. In 21 MM 168E, your bond will be, is there a victim here?
Oh, yeah.
No. Your bond will be $500 on count 1, $100 on count 2. You're not allowed to have any contact with the victim in this case. You must maintain separate residences. Do you need to return to the scene one time to get any belongings?
No, ma'am, not at all.
All right, so you understand what no contact means?
Yes, I do, and
No
that's not a
third-party
problem.
contact, no electronic contact,
No,
nothing?
none at all.
All right. I've appointed the public defender to represent you, right? Did I say that?
Yes.
Okay.
Sign this somewhere.
No, in both. Yes, it's the same victim, so, in both cases. And sir, you're not allowed to possess any firearms or ammunition, you understand?
Yes, ma'am.
All right, good luck. Sir, tell me your name, please.
Willie Brown, ma'am.
Sorry, I see why you want me to do this ahead of time. I got it. All right, good morning, sir.
Good morning.
You're here in case number 21 CF 75180. You're charged with aggravated battery, great bodily harm, domestic violence, battery, domestic violence, aggravated assault with a deadly weapon, and child abuse. I'll appoint the public defender to represent you, sir. I've reviewed the probable cause affidavits. I do find probable cause in this case. Your bond will be $5,000 on count 1, $1,000 on count 2, $2,500 on count 3, and $1,000 on count 4. If you're able to bond out, special conditions of your release will be you're not allowed to have any contact with either victim. You must maintain separate residences. You may return to the scene one time only with law enforcement. You're not allowed to possess firearms or ammunition or weapons of any kind. And I think that's it. Oh, no, I'll order that you not return to the scene. Do you understand?
Yes, ma'am.
Right, but one time with law enforcement if you need to retrieve any belongings. You understand what that means?
Yes, ma'am.
Is that a yes?
Yes, ma'am.
All right, good luck, sir.
Thank you.
Next, please tell me your name.
Good morning, man. How you doing?
Good.
My name is Wilkins Dorvos, ma'am.
All right, sir. You're here in case number 21, I think it's 21 CF 113AO. You're charged with child abuse and battery domestic violence. Ma'am, first I'm going to appoint the public defender to represent you in this case. Ma'am, if I could have you raise your right hand to be sworn.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
You have to speak really clearly and get really close to the microphone.
Yes.
All right. Ma'am, what's your name?
Marceline Rochier.
I couldn't hear that. Could you hear that?
No.
I'm sorry, I can't hear that. Can you get really close?
Marceline Rochier.
Did you guys hear that?
You have to speak louder. You have to
Right, I'm
project
sorry,
your
we
voice.
can't hear you. Can you speak really loudly?
Marceline Rochier.
Ma'am, what's your relationship to the defendant?
I'm his sister.
You're his sister? All right, does the state wish to inquire?
We're gonna just one moment. If you have any questions, I just wanted to read real quick.
Yeah, go ahead, take a moment.
Okay, sorry.
It's really hard to hear in here. It's so loud.
Judge, I'm assuming it's the victim. They blacked out the victim on
Right.
the warrant. So,
Do you want to ask her?
ma'am, the defendant's your brother?
Yes.
And you have one 13-year-old brother as well?
Yes.
Do you have any other siblings?
I got a couple more brothers and one sister.
Okay. Are you the victim from December 31st, the incident that we're here today to discuss?
Yes.
Okay. Are you in fear of your brother?
No, not at all.
Do you wish to have contact with your brother?
Can you repeat that?
Do you wish to have contact with him if he's released?
Yes.
Okay. If you at all are in fear or feel threatened, would you be comfortable contacting 911?
Yes.
I don't have any further questions, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
Ma'am, I have a question for you. Does your brother live in the same house you live in?
Yes.
All right. All right, I've reviewed the probable cause affidavit. I do find probable cause existed for your arrest. At this time, sir, I'm going to give you a bond, but I think you're being held on an immigration detainer anyway.
Yes, ma'am.
Your bond will be $5,000 on count 1, $100 on count 2. If you are able to bond out, you're not allowed to return to the scene. You must maintain separate residences. You're not allowed to have any contact with the victim in this case. You can return one time with law enforcement officers to gather your belongings if you need to. You're not allowed to possess firearms or ammunition. Do you understand?
Yes, ma'am.
All right, good luck, sir.
It's good, sir.
Yes? Thank you, ma'am. Good luck. Sir, please tell me your name.
Angel Morales.
I'm sorry?
Angel Morales.
All right, Mr. Morales, you're here in case number 21 CF 77780, 21 CF 771AO. And it looks like you were out on bond in 20 CF 8030AO. So I'm going to appoint the public defender to represent you in case number 21 CF 771AO. You're charged with possession of cocaine and possession of drug paraphernalia. Your bond in that case will be $1,000 on count 1, $100 on count 2. In 21 CF 77780, you're charged with 3 counts of burglary of an occupied dwelling, aggravated stalking, and grand theft of a motor vehicle. Is the way this is arrested, the 3 counts of burglary of a dwelling, is this a second-degree misdemeanor or it's a first-degree misdemeanor? I mean, a first-degree felony, sorry. It's a first-degree felony, but it's not a life felony, right?
Regular burglary of a dwelling's not.
But that's how it was, he's arrested on it, right?
Yes, Your Honor, just a regular burglary of a dwelling.
All right. Is there a victim here in this case? No. All right. Does the state wish to be heard on bond?
No, Your Honor, I believe my sheet shows the bonds were already entered on the burglaries. It was just the domestic violence charge that was pending bond.
Right. All right, sir. I'm going to leave your bonds in the first 3 counts at $5,000 each. As to count 4, the aggravated stalking, domestic violence, your bond will be $10,000. And then count 3, grand theft of motor vehicle, your bond will be $1,000. If you are able to post bond, you're not allowed to return to the scene. You're not allowed to have any victim contact. You're not allowed to possess a firearm or ammunition or a weapon of any kind. I'm sorry?
No.
Sorry, I thought you said something. And then, sir, you're out on bond in 20 CF 8030AO. At this time, I'm going to revoke that bond. Good luck, sir. On the revoke case? Yes. Good morning, ma'am. Please tell me your name.
Deandra Rees.
Oh. I'm not done with this one. All right, ma'am, you're here in case number 21 CF 778AO. You're charged with aggravated battery, domestic violence, great bodily harm, and criminal mischief. I reviewed the probable cause affidavit. I do find probable cause exists in this case. I'm going to appoint the public defender to represent you. there a victim in this case?
No, Your Honor.
All right. Does the state wish to be heard as to bond?
I would just highlight her history of violence and destruction of property is pretty extensive.
That it is. Do you have a recommendation as to bond?
Not a specific number, Your Honor. I mean, she's repeatedly been convicted of violence, batteries, damage of property, thefts, resisting with violence, battery on emergency care personnel. That's all.
All right. Does the defense wish to be heard?
Your Honor, we just asked for a bond of $1,500 on count 1 and list count 2 as a subsidiary is $150.
All right. Thank you. Ma'am, I'm going to set your bond at $5,000 on count 1 and $500 on count 2. If you are able to bond out, you're not allowed to return to the scene. Is this your home?
It was, but I understand that I can't return to the scene. Yes,
you
me
both
and
live
me and
there?
my child father, yes, we've been living together for over a year now. So,
All right, then
but
what
if
I'm
I
gonna
can't go
order-
back home, that's okay.
I'm going to order you to maintain a separate residence. You're allowed to return to this residence one time to gather your belongings. Unless he's moved out, then you are allowed to return to that residence. Do you understand?
Yes, ma'am.
You're not allowed to have any contact with him at all.
Yes, ma'am.
No electronic, no third party, no contact.
Yes, ma'am.
You're not allowed to possess a firearm or ammunition or a weapon of any kind. Do you understand?
Mm-hmm.
All right, good luck, ma'am. Yes. Thank you. Sir, what's your name?
And Troy Williams.
All right, sir. You're here in case number 21 CF 779AO. Charged
Your Honor,
with,
the defense does have probable cause challenges.
all right, one moment. You're charged with kidnapping, domestic violence, fleeing or attempting to elude a police officer, 2 counts, child abuse, possession of firearm by a convicted felon. Was the PD already appointed?
No, Your Honor, I don't believe so.
All right, well, I'll appoint you to represent him. All right, go ahead. What do you wish to be heard
I would
on?
like to have a probable cause challenge for the kidnapping and the possession of a firearm by a convicted felon. With the kidnapping, it appears that the alleged victim is going to be a willful passenger in the car. I would assume if they're in a relationship, given my client's history, that she knew the consequences of riding with a person like my client. It appears that my client, per the arrest affidavit, fled in the car, and that the alleged victim was seated in the car. I would like to provide something with the state and for Your Honor when it comes to kidnapping.
Thank you.
If you look at I would say the 3rd paragraph, it says given when 3B is alleged. Per Faison versus State, in order for it to be a kidnapping, the confinement, the abduction, or the imprisonment, I would like you to pay close attention to B. It must not be the kind inherent in the nature of the applicable felony. The applicable felony in this case is going to be the fleeing and eluding. Fleeing and eluding could only be done in a motorized vehicle, such as an automobile. It can't be done on foot. My client was, per the arrest affidavit, he was engaged in the fleeing with the police officer in the vehicle, Your Honor. There was no intent to kidnap at all. If they were driving in a car, the police officer gets behind them, tries to flag them down, and he takes off running in the car. The alleged victim claims that she told him to stop, but we have no substantial proof of that fact, Your Honor. It's basically her word against my client. When the car stopped, the alleged victim in this case didn't even stay in place to protest her innocence. It appears that she actually fled in the opposite direction. I would argue, Your Honor, that this isn't a kidnapping. It's a fleeing and eluding while she was a passenger. And whether she actually told him to stop or not, that's going to be in serious question. As it relates to the possession of a firearm by a convicted felon, per the arrest affidavit, the gun was found in a female's purse. The alleged victim claimed that it was her purse. The purse was found in the passenger seat of the car. My client did not admit to knowing anything of the purse. He didn't admit to owning the purse, holding the purse, or he didn't admit to any knowledge of the firearm that was located inside of the purse. Law enforcement in this case did not see my client with the purse or see him place anything in the purse. My client was not found with the purse in his immediate possession or the firearm, Your Honor. I would argue that probable cause does not exist for kidnapping or possession of firearm by a convicted felon.
All right. State.
So the gun, it wasn't found in the car. It was found in the purse in a trash bin in the location where the defendant was hiding. So specifically, they notate the passenger went one way down whatever this road is, India Atlantic Drive. So the passenger went one way. The defendant left the driver's seat and went the other way into the address of 5101 India Atlantic Drive. That's where the purse was found with the gun. So the passenger definitely didn't put it there because she went the other way. The passenger confirmed that was her purse that was in the car at the time. That leaves only one person to take it and put it in that trash bin, would be the defendant. The passenger stated she didn't own a gun, she didn't know a gun was in the bag. So that circumstantial evidence is sufficient to prove a case of PFCF, and that would lead the defendant to be the one in possession who hid the gun. As far as the kidnapping is concerned, I mean, you could argue it was for A, that it was to hold her as a hostage. I mean, he's running from the police with multiple people in the car. You could argue it's for C, that he's terrorizing her. I mean, she's literally in fear for her life while he's running from the cops, putting her life and her child's life in jeopardy, asking to be released, and he's refusing to do so. He could have just as easily pulled over and let her out and then continued on his flight, but he didn't do that. He kept her in the car and continued on his flight into oncoming traffic, putting their safety at risk. So I wouldn't argue that it's only to commit or facilitate the commission of the fleeing. That's all, Your Honor.
All right. Thank you both. I appreciate your impassioned arguments. At this time, I find probable cause exists for each of the crimes that are in the arrest affidavit. Counselor, I also want to draw your attention to at the bottom of the probable cause affidavit, your client claimed a phone found by officers, and he's holding the firearm in the photo on the phone. So I'm finding probable cause. Probable cause does not mean there's proof beyond a reasonable doubt. That's for a different day. But I find that there is probable cause for your arrest in this case. Thank you. At this time, wait, I'm going to hear from the person who's standing in the box. Ma'am, please raise your right hand to be sworn.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, please tell me your name.
Naomi Porter.
I'm sorry, you have to speak really loudly.
Naomi Porter.
Miss Porter. Does the state wish to inquire?
I'm guessing this is a result of, do you wish to have contact with him if he's released?
Yes, but me and my child was never in the car. And I stated that, and they threatened me with DCL.
Do you wish to have contact with him if released?
Yes.
Okay. Would you contact law enforcement if you were in fear?
Yes.
Okay.
But I was never in the car.
Okay, Your Honor, no further questions.
Ma'am, what's your relationship with Mr. Williams?
My boyfriend.
I'm sorry?
Boyfriend.
He's your boyfriend?
Yes.
How long have you been in that relationship?
Like 5 years. 5 years.
5? Okay, sorry. The masks make it difficult, but you have to leave it on. So that's why I keep asking you to repeat it. We're trying to make a record, and I have to be sure I understand you. So thank
Okay.
you. I appreciate it. Are you afraid of Mr. Williams?
No.
Does the defense wish to inquire?
Yes. Ma'am, is it your testimony today that you were never inside that car?
No, I was never inside the car.
Can I have her sworn in so she can say this under oath, please?
Did we do
Was she sworn in? I
Right,
just want
she
to
was
make
sworn.
sure.
Yeah, she was sworn.
Okay.
Yes.
Go
So, ma'am,
ahead.
you understand your testimony is under oath, and we're making a record.
Yes.
Okay.
Is it your testimony that you were never inside the car?
I was never inside the car.
So, my client did not kidnap you?
No.
And you guys were never inside the car together?
No, me and my daughter's never inside the car. We pulled up with my friend Takara Johnson.
So, when he pulled up, the car basically drove off?
No, I was never there. I came later after they already had him arrested.
Oh, so you were never there?
I was never there.
Never on the scene?
No.
No further questions, Your Honor.
All right, thank you, ma'am. All right, so on count 1, your bond is going to be $10,000. On count 2, your bond is $5,000. On count 3, $5,000. Count 4, $4,000. I'm sorry, $1,000. Count 5, $4,000. If you are able to bond out, you're not allowed to have any contact with Miss Porter. You're not allowed to possess a firearm or ammunition or weapons of any kind. Do you live together?
No.
No? Okay. So I'll still order that you maintain separate residences. Thank you. Good luck. Please tell me your name.
Travis Williams.
Mr. Williams, you're here in case number 21 CF 610AR80, charged with aggravated battery with a deadly weapon, domestic violence, battery by strangulation, domestic violence. Is there a victim in this case?
No, Your Honor.
All right. I reviewed the probable cause affidavit. Oh, there is probable cause for your arrest. I'm going to appoint the public defender to represent you. Do you live at this location?
No, ma'am.
No? Okay. I'm going to order that you not return to the scene. You have to maintain a separate residence. You're not allowed to have any contact with the victim. If you need to return there to get, do you need to return to get any belongings?
Yes, ma'am.
All right, I'll allow you to do that one time with law enforcement. Do you understand?
Okay. Is it possible to get a no physical contact or whatever that's called? We have a child together and...
It's not possible this morning, but that's
Okay.
possible through your attorney.
Okay.
So as of today, you can't have any contact, electronic or anything.
Okay.
No third-party contact either. But I've appointed the public defender to represent you. They can file a motion in front of the judge who will be hearing this case, and that judge can modify my order.
Okay.
But until a judge modifies that order, don't have any contact with her. Do you understand?
Yes, ma'am.
All right. Oh, sorry. Your bond is $5,000 on count 1 and $5,000 on count 2. You're not allowed to possess a firearm or any ammunition or weapons of any kind. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Thank you. Is there any way that we can have the bond lowered?
Your attorney can file a motion.
Oh, okay.
Yes.
Thank you.
Good luck. Good morning, sir. What's your name?
Drew Bay.
Did you say Drew Bay?
Yes, ma'am.
Okay. You're here in case number 21 MM465AO, charged with battery, dating violence. Is there a victim in this case?
No, Your Honor.
All right, sir, I reviewed the probable cause affidavit. There is probable cause in this case for your arrest. Your bond, I'm going to appoint the public defender to represent you. Your bond will be $500. You're not allowed to have any victim contact. You're not allowed to... Do you live in this location?
Yes, ma'am.
All right, I'm going to order that you maintain separate residences. What that means is if she lives there, you can't. But if she moves out, you can.
It's my place.
Okay, so as long as she's not living there, you can live there. But you're not allowed to have any contact with her. No electronic contact, no third party, nothing.
Correct.
You're not allowed to possess a firearm or ammunition or a weapon of any kind. Do you have any questions?
No,
All right, good luck, sir. Sir, please
morning,
tell me your
Judge.
name. Good morning.
George Bondi.
Mr. Bondi, you're hearing case number 21MM466AO, charged with battery, domestic violence. I reviewed the probable cause affidavit in this case, and I do find probable cause exists for your arrest. I'll appoint the public defender to represent you.
Thank you.
There's no victim here.
No, Your Honor.
Is this your house, sir?
It is my house.
But your daughter lives there?
I'm letting her live there, yes, while she gets over her divorce from 2 years ago.
All right.
And she established another relationship in the meantime.
All right, sir.
I understand the conditions. I have plans to remain at a friend's house for
Okay.
the meanwhile.
Hold on. Let me impose those conditions.
Thank you.
First, I had to review it one more time. I'm going to order that you maintain a separate residence. So if your daughter moves out of your house, you can return to the house. But if she doesn't move out, you can't live there.
I plan on filing for an eviction notice for her.
All right, you can do that and talk to your attorney about that. Because
Yes.
I appointed the public defender to represent you. And they can also talk to the victim, and they can schedule another hearing in front of the judge who will be hearing this case later. But for the time being, you're not allowed to have contact with her at all.
I don't want to have contact with
All
her,
right.
ma'am.
And you have to maintain a separate residence. You can return one time to the scene with law enforcement to get your belongings.
Thank you.
But like I said, if she moves out, you're allowed to live there because it's your house,
Thank you.
but not while she's there. Do you understand?
Perfectly.
All right, you can't possess a firearm or ammunition either.
Very
All right,
well.
good luck, sir.
Thank you, ma'am.
I'm sorry?
What was the bond?
Oh, bond, $500.
Thank you.
Thank you.
Thank you.
Oh, I wrote it, but then I didn't say it.
Sorry.
Good morning, sir. Please tell me your name.
Miguel Jimenez.
Oh, I forgot. Did you say Miguel Jimenez?
Miguel Jimenez.
Okay. Sir, you're here in 21MM38AW, charged with battery domestic violence. I find there is probable cause for your arrest in this case. I'll appoint the public defender to represent you. Is there a victim present?
No, Your Honor.
No. Sir, I'm going to give you a bond in this case, but you also have an immigration hold. So I don't know that you'll be able to bond out until that hold is cleared. The bond is $500. If you are able to bond out, you must maintain a separate residence. You're not allowed to have any contact with the victim at all. That means no third-party contact, no electronic contact, nothing. Do you understand?
Yes, ma'am.
Do you understand?
Yes, ma'am.
Okay. Sorry, it's hard to hear in here, and I have to make sure that I get that on the record. All right, you're not allowed to possess a firearm or any ammunition. Good luck, sir.
You did state I have a immigration hold, you said?
Yes,
So with that, I can't bond out,
right,
right?
right,
So there's no point of bonding out?
right. They're not going to release you as long as that hold is pending.
All right, thank you.
Yes, sir.
Kristen Ramos refused to attend, Your Honor.
Oh.
Think to me as good, Your Honor.
Okay, this is case number 21MM453AO. Wait, she's not for this case. Kristen Ramos. No. Okay. So I find her refusal a voluntary waiver. This is, I just said the case number, charged with battery domestic violence. There is probable cause. I'm going to appoint the public defender to represent her. And the victim is not here. Ryan Ramos is not here. He was supposed to be. No?
Yes, the victim is here, Your Honor.
Oh, he is here. Good morning, sir. Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Can you state your name for the record, please?
Ryan Ramos.
All right, sir, hold on one second. Your attorney wanted to be present electronically.
Okay.
How do I make that happen?
I can call.
You can? Okay.
Yes.
There's the phone number.
Just give me 1 second.
Okay.
Your Honor,
Hold on one second, sir. Yes.
Are you saying that Kristen Ramos has a private attorney?
Yes.
Okay.
Yes, I will not. Oh, no, no, no. No, she doesn't. Her husband, her victim does.
Oh, okay.
Sorry.
Your Honor, ma'am.
Yes.
She does have
She does have a
She
private
does.
attorney?
Yes.
Do you know who that is?
Matthew Bark.
Matthew Bark? Well, we could call him too. So then I will not appoint the public defender.
We're gonna hit the top button on the screen.
Hello.
Hi, good morning.
Good morning. This is Judge Gibson.
Hi, this is Attorney Carrie Rentz. I represent the alleged victim, Ryan Ramos.
All right. Thank you, Ms. Rins, for appearing electronically. Your client is here. Kristen Ramos refused to come to court today. I'm finding her refusal to be a voluntary waiver of her appearance. However, her husband just informed us that she has an attorney. Is there a way to get two of them on the line? No.
If you want me to, I could conference him in.
Ooh, can you do that?
Yes.
That would be fabulous.
Give me 1 second. Okay.
Let's see if we can make this work.
Excuse me, ma'am.
This is perfect.
Your Honor?
Yes.
Oh, hi. It's Attorney Carrie Rentz again. I have Attorney Matthews Bark on the phone as well. He represents Ms. Ramos.
Great. Thank you both.
Good morning, Your Honor.
Good morning, Counselor. We're hearing case number 21MM453AO. Ms. Ramos has refused to come to court, but her husband, the alleged victim in the case, is here. Does the state wish to inquire? And sworn. He's been sworn.
Thank you, Your Honor. Sir, do you wish to have contact with Ms. Ramos?
Yes, I do.
Do you wish for her to return to the residence?
Yes, I want her to return home.
Do you share the residence?
Yes, we do.
Is there any prior history of domestic violence between the two of you?
No, ma'am. No, sir.
And if in fear, would you be comfortable contacting 911 to come out and assist?
Yes.
Okay. No further questions, Your Honor.
Mr. Bark, do you wish to inquire?
No, Your Honor.
All right. I reviewed the probable cause affidavit. I do find probable cause existed for the arrest here. I'll grant your client a $500 bond. Based on the testimony here in court today, I'll also allow peaceful contact, no hostile contact. And Mr. Ramos, I just want to be sure that I'm clear. You don't want me to order your wife to maintain a separate residence?
No.
You have to answer out loud.
Oh, no, I want her to come home with me.
You want her to come home?
Yes, ma'am.
All right, then I will allow her to come home and live in the same residence, but no hostile contact.
Yes, ma'am.
All right. Does either of the attorneys wish to say anything else? Any other items before the court?
No, Your
I'd
Honor.
just like to thank the court. Thank you.
Absolutely. Good luck, everyone.
Thank you.
All right, thank you, Judge. Have a good
Have a
day.
good one. So then I press end call. It doesn't, the top is still lit up green. Oh, it just lit up red. All right. Good morning, sir. Please tell me your name.
Sean Spain.
You're here in 21 MM 46780, charged with battery domestic violence. I reviewed the probable cause affidavit. I do find probable cause existed for your arrest. Ma'am, please raise your right hand to be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Tell me your name.
Catherine Joyce.
Catherine
Joyce. Do you have Catherine
Joyce.
Ann Joyce?
Okay. Sorry. The masks make it really hard to hear, but you have to leave it on.
Okay.
So just get really close to the microphone, please, and speak up. Thank
Okay,
you.
how's that?
Much better.
Okay.
Do you have a private attorney in this case?
A private attorney, Judge? No.
Right. Okay. I'm going to appoint the public defender to represent you. Does the state wish to inquire of Ms. Joyce?
Good morning, ma'am. Do you wish to have contact?
Yeah, yes, I mean, contact as far as talking to you right now?
No, with, I'm sorry, Mr. Spain.
Yes, absolutely.
Do you live together?
We do.
How long have you been together?
12 years.
Have you lived in Orlando for all 12 years?
No, we just moved to Orlando in September.
Okay. And if you felt in fear or there was any sort of incidents, would you be comfortable contacting 911?
Oh, yeah, absolutely. I've never had this type of problem before. Like, I think I just overreact. We both had some champagne. And, like, I've, like, replayed it in my mind over and over again about, like, the situation. And it's just, like...
But for 12 years, you haven't had any instance of violence?
Never.
Okay. No further questions, Your Honor.
Does the defense wish to inquire?
Nothing from defense, Your Honor.
He does qualify for pretrial release?
Yes, Your Honor.
Ma'am, does he live with you?
Yes.
You don't want me to order him to maintain a separate residence?
No, I mean, I'm here to pick, I want to pick him up or do whatever because we run a business together, we live together, like, this has never happened before.
All right, I'm going to place the defendant on pretrial release. Special conditions, no hostile contact, only peaceful contact with the victim. Do you understand what that means?
Yes, ma'am.
If you raise your voice, you're violating that condition. Do you understand?
Yes, ma'am.
All right. I will allow him to return to the residence based on the testimony provided this morning. But ma'am, you understand that even if he raises his voice, you call the police.
Yes, ma'am.
All right. You're not allowed to have alcohol. You'll be subjected to random screens while on pretrial release.
Okay.
You're not allowed to possess firearms or ammunition or weapons of any kind. Do you understand?
Yes, ma'am.
All right. Yes, for alcohol. No alcohol.
Okay.
All right.
Yes, ma'am.
Okay. Good luck.
Thank you.
Good luck, ma'am. Thank you for coming.
Okay, thank you.
Sir, please tell me your name.
Shamar Sparrow.
All right. Good morning, Mr. Sparrow. You're here in case number 21 MM 45080, charged with battery, domestic violence. I do find probable cause existed for your arrest. I'll appoint the public defender to represent you. Is there a victim in this case? All right. At this time, I'll set your bond at $500. Order that you maintain a separate residence. You're not allowed to have any contact with the victim. Do you understand what that means?
Yes, ma'am.
No electronic contact, no third-party contact, none. You understand?
Yes, ma'am.
You're not allowed to possess a firearm or ammunition or a weapon of any kind. All right, good luck, sir. Sir, tell me your name.
Raymond Lamont.
Good morning, Mr. Lamont.
Morning.
You're here in 21 CT 538AO, charged with driving under the influence and refusal to submit to a DUI test. Do you have an attorney representing you?
I don't at the current time. I would like to get an attorney though.
Would you like me to appoint the public defender to represent you?
Well, yeah. Yes. Please.
If you have the money to hire an attorney, you can do that.
That's what I mean.
Why
That's
I asked.
Yeah, no, that's what I mean. That's what I want to do.
You have the money to hire an attorney.
Absolutely.
Okay, so you don't want me to appoint the public defender to represent you?
No.
All right, I'm not going to appoint the public defender at this time. I do find probable cause exists for your arrest. Your bond amounts are $500 on count 1, $100 on count 2. If you're able to bond out, you're not allowed to have any alcohol. You cannot possess or consume any alcohol. You understand?
Yes, ma'am.
You cannot drive a vehicle without a valid driver's license, which you won't have at this time. So don't drive, and you're not allowed to possess any alcohol or consume it. State,
Yes,
are
Your
there any
Honor.
other special conditions the court has to impose on a DUI
I don't believe so, Your Honor.
at this time? Okay.
Not for bond.
Oh, wait, he does qualify for pretrial release. That's what you just showed me. But I can do pretrial release with the monetary bond, right?
You could, Your Honor.
All right. I'm also going to place you on pretrial release.
Okay.
What that means is you're going to be subjected to random alcohol screens, and you have to check in with pretrial release as they tell you. Do you understand?
Yes, ma'am.
All right. Good luck, sir.
Thank you.
Your Honor, Rose refused court.
Savannah Rhodes.
Yes.
Thank you. Case number. Oh, hold on. 2020 CT 62028O. A failure to appear. The bond is already set at $2,000. I'll find her refusal to come, a knowing waiver of her appearance, and in 20 CF 14919AO, I'm going to revoke her bonds. And I'll appoint the public defender to represent her. Good morning, sir. Please tell me your name.
Lloyd Walker.
Hold on. Did you say Walker?
Yes.
I believe he bonded on his case, Your Honor. He just has an ice detainer.
I see it. Sorry. It's right here. Okay, so this is case number 2021 CT 54080. You bonded out already. You're charged with driving while license suspended, but you have an ICE detainer, so at this time you won't be released. You understand? Was the public defender appointed? I'm going to appoint the public defender to represent you. All right, good luck, sir. All right, I got a little bit behind, so it's out of order.
Who do you have next, Your Honor?
Hold on 1 second. I'm behind on my signing. One day I'll catch up to how quickly Judge Carter signs everything. A Russian interpreter? Okay, do in-jail arraignments. So next I have Jose Velasquez Meza. Meza Velasquez?
He's medical, Your Honor.
Oh. Public defender represents him. This is case number 21 CT 300AO.
Your Honor, we'll waive his appearance and enter a plea of not guilty.
All right. It'll stay in Division 63.
Division 63 pretrial conference, February 18th at 1 p.m. at 12C.
I didn't realize he has 2 cases, so that is the same for 21 CT 301AO. Oh my gosh. 21 CT 302AO, 21 CT 303AO. All right. So those will all, are they all in the same division and they'll track together?
Yes.
All right, thank you. Next I have Nikese Johnson, 2020 MM 8679AO,
He's also medical, Your Honor.
represented by the Office of the Public Defender.
Your Honor, we'll waive and enter a plea of not guilty.
This is Division 83.
Division 83 pretrial conference, February 24th at 9 a.m. in 6C.
Oh, try to do that. All right. Raleigh Rucker Lawrence, or Lawrence Rucker, 21 MM 302AO. He what?
He's on his way.
Oh, he's on his way. So is this just like my docket? It tells me everyone. Right, but that's all it is. Okay. I just want to make sure I understand what everything is.
After this case, we have the rest of the inspector on the line.
Okay.
After this case, we have the rest of the inspector on the line.
Good morning, sir. What's your name?
Lawrence Rucker.
All right, Mr. Rucker, you're here in 2021 MM 302AO. You're charged with possession of drug paraphernalia, and you are represented by the Office of the Public Defender.
I believe there may be an offer, Your Honor, of credit time served adjudication.
Have you had time to discuss that with your client?
Your Honor, because of COVID-19, we're not fully speaking to everyone, so we just do the offers like right on the record.
I see. All right.
Your Honor, he would like to accept the offer.
All right, please raise your right hand to be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you had a chance to briefly discuss with your attorney the state's offer of credit time served,
Yes, ma'am.
and he's been in jail 52 days? All right. You understand that if you enter a plea of guilty or no contest this morning, I'll sentence you today. You're going to give up your right to a jury trial, your right to confront the witnesses brought by the state, your right to call your own witnesses. You're going to give up all of those rights and enter a plea today, and I'll sentence you to credit time served.
Yes, ma'am.
Is that what you want to do?
Yes, ma'am.
You understand that if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am, I understand.
All right, you understand if you're on probation in any jurisdiction, this plea could violate that probation?
Yes, ma'am, I understand.
Are you under the influence of drugs or alcohol?
No, ma'am.
You shouldn't be after 52 days. I don't know if you
No,
were
ma'am.
before, but not now. All right. How do you wish to plead to the charge of possession of drug paraphernalia?
Guilty.
No contest.
No, no contest. No contest.
Well, they have the same effect. You understand I'll be sentencing you today.
Oh, adjudication of guilt. You're right.
Right. So are you pleading guilty or no contest?
No contest, Your Honor.
A whole lot of people. All right. I'll accept your plea of no contest. I find it's freely and voluntarily given. I'll adjudicate you guilty, order you to serve 52 days in the county jail, give you credit for the 52 days that you've served. I'm going to order that you pay court costs. I think that's, I don't remember now. It's around $300. I'm going to give you a year to pay those court costs. Do you understand?
Yes, ma'am.
All
That
right.
would help me greatly.
All right. Good luck, sir.
Thank you.
Next, we have our interpreter case.
Your Honor, she bonded.
I'm sorry?
She bonded.
The Russian?
Yes, Your Honor.
Whoops. Okay. Please tell the interpreter. Great. So this is case number 20MM753080, State versus Dilnoza Inogamon. It was a KBS and she bonded out. Okay. Next I have Charles Smith, 20MM8998AO. Good morning. Please tell me your name.
Charles Smith.
Sir, you're here today charged with possession of drug paraphernalia. I see that you're represented by the Office of the Public Defender. Does the state have an offer for him?
Your Honor, be adjudication, credit time served. There is a cost of investigation of $82.50 to the Orlando Police Department.
Your Honor, the defense, I think we filed a waiver of arraignment in this case. Just want to make sure.
I don't know, but since he's here, are you interested in accepting the state's offer?
No.
No.
Have a moment, Your Honor, please.
Yes. If he doesn't want to accept the offer, that's fine. He doesn't have to.
Yeah, it might time.
So that's the, your calculation. Downtown closed. Do I got a bond? No, I don't got a bond on my charge. In the bond, I need to reduce the bond. I need to buy the reduction. Which cases? I got two cases. I got
You're only here for this case.
Can you,
It's what?
I only can afford $100. Can you bond reduction?
Got it.
This, because this is the district. This is district 17 or 12.
But you want to clean up, or you want to clean the case out? I told the station how to get best interest. You want to clean out,
Your Honor.
Yes, sir.
Which case? Which case this is?
This is 20MM8998AO. You're charged with possession of drug paraphernalia. The state's offer is an adjudication of guilt and credit time served. Well, they're asking the court to adjudicate you guilty, which I am inclined to do.
Yeah.
But I imagine what your attorney is talking to you about is some other matters that I'm not aware of, and the effect that this plea could have on other matters. So you need to have a conversation with your attorney. I'm fine with that. And then tell the court what it is that you want to do this morning.
Your Honor, I take the plea.
All right, Mr. Smith, you had a chance to discuss this with your attorney?
Yes.
All right, please raise your right hand and be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you did have a chance to discuss this with your attorney, and at this time, you want to enter a plea of guilty or no contest.
No contest.
All right, you understand that by entering a plea of no contest today, you're giving up or waiving certain rights. Your right to a jury trial, your right to confront the witnesses called by the state, the right to call witnesses on your own behalf, the right to testify on your behalf. You're giving up all of those rights to enter this plea today.
Yeah.
Is that what you want to do?
I got a letter, this is the Division 17, right?
No, this is a Division 80 case.
Division 8 case?
Yes.
So that's Professor got bond for. I'm supposed to have been on the court for Division 17 today.
I don't know about that case, and that's probably what your attorney was talking to you about. But we're not addressing that case today. Today, we're addressing the possession of paraphernalia charge. If you want to enter a plea of not guilty and continue talking to your attorney about this case.
I'm gonna continue because
all right.
I can't beat the case anyways.
All right. So your next court date is going to be February 19th at 9 a.m.
I'm going to enter. I'm going to go with the state into no contest.
Oh, you want to enter a plea of no contest?
No contest. And accept the state offer.
Okay. You understand that by doing that, you're giving up all your constitutional rights to challenge any of this. You're going to admit that you're guilty, or that you're not going to contest the matter, and I'm going to sentence you today. That's what you want to do?
Yes.
You understand that if you're on probation, this plea could violate that probation?
Yeah, I'm not on probation.
All right.
Yeah.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yeah.
All right. Has anyone threatened you or promised you anything other than what the state just offered you to get you to enter this plea?
No.
All right. At this time, I'll accept your plea of no contest, adjudicate you guilty, order you to serve 32 days in jail, give you credit for the 32 days that you've served. I'll also order that you pay the cost of investigation, if the state can put that on the record once more.
Yes, Your Honor, it's $82.50 to the Orlando Police Department.
I'm going to order that you pay that amount to the Orlando Police Department and court costs, and I will give you 1 year to pay the cost of investigation and your court costs. Do you understand?
Uh-huh.
All right. Good luck, sir. Thank you. All right, next I have Brandon Zorn, 20MM 57680. I see. I think that's all I have for Angela Raymonds. I have a 33-day motion. 2020 CF 1430080, State versus William Poole, charged with aggravated battery, great bodily harm. State.
This is 1430080.
1430080. Yes, CF.
I believe a notice of non-filing was submitted yesterday, Your Honor.
When you say notice of non-filing, does that mean you filed an announcement of no information?
No, no. It's essentially a notice by our office that we're not going to file an information prior to the 33rd day, but ultimately the case can be filed. So it's just we call it INN 27. Right. It's a notice of non-filing at this time.
So at this time, I'll grant the motion.
Yes, Your Honor.
Thank you. All right, next I have a list of possible 33-day motions. But I'm confused.
Yeah, that's the rest of the list. That's everybody that you should have.
So if it's not on the list, oh, it's just out of order.
Yeah.
I see. Also, it says the other judges. It says appeared before the Honorable Amy Carter or Carly Wish. Public Defender's Office. all of your orders for the 33-day motions have the wrong judges listed. Can you guys make those changes?
Yes, Your Honor.
All right, I'll sign them today, depending on the motions, but after that, can you make that change?
Thank you, Your Honor. I will.
All right. So first up, I have State of Florida versus Joseph Adams, 20 CF 14831AO.
I'm sorry, Your Honor, that's not on the list that I have.
It's on the back, it's the last one that I have.
Oh.
So, sorry, I'm calling out of order, but then it was the first one that appeared here.
Okay, I see. Yes, Your Honor. The same notice of non-filing, Your Honor.
All right. So at this time, I'll grant that motion. Next, I have Regina, State of Florida versus Regina Battle, 20 CF 13332AO.
In that case, a no information notice was actually filed.
So I don't need to sign the order then? Won't the defendant be released without the order?
That I don't know.
Does the public defender's office know? All right, I'm signing it.
Yes, Your Honor. If there's no non-filing, the defense will ask for our motion to be granted.
Okay, I'll grant the motion. Next, I have Rashawn Brown, 20 CF 14097AO.
The notice of non-filing.
All right, then I'll grant the motion. Next, State versus David Cook, 20 CF 14968AO.
Notice of non-filing.
But isn't today the 32nd day?
I'm not sure.
So I have on my list that this is the 32nd day, not the 33rd day.
I mean, if we're not going to file on it before the 30th, it's a drug case. They're waiting on the FDLE results.
All right, so they're not going to file it by tomorrow anyway?
No, on the drug cases, FDLE usually takes more than 33 days to get results back.
All right, thank you, Counselor. Oh, was I supposed to do this? Whoops. State versus Bakari Edwards, 20 CF 14965AO.
Same thing, Your Honor, notice of non-filing.
Okay. I also have this as the 32nd day. State versus Billy Ferris, 20 CF 14904AO.
Notice of non-filing, Your Honor.
All right, I'll grant the motion. State versus Kieran Moore, 20 CF 13485AO.
Notice of non-filing, Your Honor.
He bonded out already? If he bonded out, why do we have this motion?
No, Your Honor, he has not bonded.
Oh, he has not? Okay.
No.
He had 2 cases on my list.
Oh, 20 CF 13493. Is that the same one?
That's a different case number, same defendant, I believe.
Okay, all right.
The notice
In
of
this case-
non-filing is as well, Your Honor.
All right, then I'll grant the motion. State versus Christopher Moats, 20 CF 14775AO.
Notice of non-filing.
I'll grant that motion. Ooh, that's all I have. Does anyone have any other business before the court this morning?
No, Your Honor.
All right. Court will be in recess until this afternoon.
You start back at 1:30 on 1 o'clock?
I don't, 1 o'clock? Do we know? All right, we'll say 1 o'clock.
Okay, thank you.
Thank you all. Have a nice day.
Now put your mask on. Cover your nose. Cover your face. Cover your nose. Thank you, sir. Tell me your name.
Caballero Garcia.
All right. Mr. Garcia, you are here in 2021 MM 456 AO on a charge of trespass. You were arrested for a charge of trespass under the structure of conveyance. Mr. Miller, do you have an offer for Mr. Garcia?
Adjudication, credit time served, court costs, no return to this location.
All right, Mr. Garcia, the state of Florida is offering you an adjudication of guilt. Credit for the time that you spent, which I think is 2 days in the Orange County Jail. And you have court costs, and you cannot return to this location where you're trespassed.
Okay.
Is that an offer you want to accept this afternoon?
Yes.
All right, could you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, put your hand down. Tell me your name one more time.
Caballero Garcia.
All right, Mr. Garcia, you are here in 2021 MM 456 AO on being charged with trespass on property other than a structure or conveyance. That is a first-degree misdemeanor. It's punishable by 1 year in the county jail and a $1,000 fine. Do you understand that?
Okay.
Do you want to enter a plea of guilty or no contest to this charge?
I trespassed in that church property.
Do you want to
yes.
enter a plea of guilty or no contest?
Guilty.
You understand by entering a plea of guilty, you're giving up the right to have a trial.
I should go today.
No. Do you understand you're giving up the right to have a trial?
Trial, no problem.
Do you understand English, sir?
Yeah, I understand English.
All right. Do you answer my question? Do you understand by entering this plea, you're giving up a right? One of them is giving up a right to have a trial. Do you understand you're giving up that right?
Mm-hmm.
Just say yes or no.
Yes.
All right. Do you understand you're giving up the right to have an attorney appointed to represent you at a trial?
Yes.
All right. Are you under the influence of any drugs or alcohol at this time?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation?
I'm Puerto Rican.
Well, do you understand if you're not a United States citizen, it could subject you to deportation?
Okay. I understand that.
All right. I reviewed the charging affidavit earlier today. I do find a factual basis for the entering of your plea. I'll accept your plea of guilty in this case. I'll adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in the Orange County Jail. I will impose $273 in court costs and costs of prosecution. And I ordered you not return to the location where this incident happened.
All right.
When you're not with us, do you work? Do you work?
Yes, I do work.
What do you do for a living?
I'm doing volunteer work at the moment.
All right. Do you do any paid work?
No.
All right. When was the last time you had a paid job?
Yesterday.
Yesterday, what was that job you were doing yesterday?
Landscaping.
Landscaping? Are you going to go back to landscaping when you leave jail?
Mm-hmm.
All right. Or did you pay these costs within 1 year of today's date? Do you understand that?
Repeat that again.
I'll order that you pay these costs within 1 year of today's date.
All right. I leave today.
Yeah, you're out of jail today.
Okay.
All right. Thank you, sir. Have a great day.
You too.
Your Honor?
Yes, sir.
Albert Cunningham?
Yes,
He
sir.
refused to attend.
All right. I'm going to appoint the public defender like to represent Mr. Cunningham in this case. Do you all want to waive his appearance at today's initial appearance?
Yes, we'll waive his appearance, Your Honor.
All right. Mr. Cunningham was arrested in 2021, MM 458 AO on charge of trespass after warning. I did find probable cause for his arrest. I'll stay his bonds at $500. He's out on bond in 2021, MM 363 AO. The court's going to revoke his RR status And I'm going to place a bond in the amount of $500 on that case as well. Thank you. All right, sir, tell me your name.
Elwood Smith.
All right, Mr. Smith, you are here in 2021 MM 460AO on a charge of simple trespass.
Yes, sir.
I did find probable cause for your arrest in this case. I'm going to state the bonds at the amount of $250. I'm going to appoint the public defender to represent you in this case.
Can I just plea out today?
Mr. Miller,
pleable charge.
You have an offer for this case?
Yeah, my offer is adjudication of guilt, 30 days in Orange County Jail.
All right. Is that an offer you want to take today on this charge?
Yeah, I might as well.
Your Honor, okay, since this is a state attorney who is filling in for one of the regular state attorneys.
Yep.
30 days, since I've been doing this, that's like the harshest sentence I've seen.
Yeah, I mean,
I was going to offer more than that. He's out on bond.
Correct. That was
and 20 CF 9775 for trespassing and stealing from the same exact Wawa. The bond conditions on that case are to not return to that scene and not have contact with those victims. So realistically, his bond should be revoked on that for not only violating bond conditions, but committing a new law offense, and then he's going to sit in jail on no bond on the felonies, and then have the bond on this one.
Which I understand that, but 30 days, that's for a BRC plea, that's pretty extreme.
When he had 7 prior trespasses.
Mr. Thompson. All right.
Plead to 15 days.
Listen, if Mr. Smith.
Yes, sir.
No, not talking. For Mr. Smith, I'm talking to your attorney, Mr. Thompson, who's standing to your left. I did review the other case because I was considering whether he was going to plead his one case and not take action on his other case. I wasn't really agreeable to that for the same reasons that Mr. Miller just iterated, that it was the same location. It wasn't like he went across the street. He didn't even go across the street to the next gas station. He said he went back to the very same place that the judge had ordered him not to go back to just, was that like a few weeks ago? So I was going to revoke his bond as to that count. So the question is, if he wants to take the offer, that's fine. If he doesn't want to take the offer, that's also fine. But it's up to him what he wants to do.
Excuse me, sir. If I take the offer, can you just leave the bond alone and not revoke it? If I just go ahead and take the 30 days? So I'll
Mr. Miller,
be able
have
to
you
get
guys
out?
charged this case? The 2020 case?
'Cause, I mean, if I can get out in 30 days, I might not lose my job.
One second. It looks like that case was filed on 10/15 with a pretrial conference scheduled for February 24th. And Judge Stowbridge, Division 14.
All right. Well, Mr. Thompson, you want to have time to talk to Mr. Smith for a second?
Oh, well, yeah, he said that if he wants to take it, as long as you don't, if you would not revoke the Allen bond charge.
All right.
Please.
I'll leave his bonds as set. That does foreclose the state of Florida from talking to Judge Stowbridge about the same thing. You understand that, Mr. Smith?
What's that now?
The state of Florida can ask Judge Stowbridge to strike that, to revoke your bond. Even though I'm not taking any action on it today, that once the state attorney who's assigned to this case gets wind of it, they may decide that to ask Judge Stowbridge to strike your bond. Do you understand that?
Right, so when I go to court on February for that, they might time serve me, or, I mean...
Well, you're not getting... So what's going to happen? If you take the plea today, you're not going to get any time served as to your felony case. You're only going to be in jail on this misdemeanor trespass charge.
What felony case?
You have a pay theft with 2 prior theft convictions and a trespass case from the same location where you were arrested at the Wawa. I'm not sure that case is true or not, whether the facts are true or not about that case, but I'm telling you that's what that case is about. Now, I just want to have you make sure you understand that Judge Strobridge, if on the state's motion or her own motion, can revoke your bonds as to the felony case, and you're still not getting any time served because you're out on bond on that case while you're serving the 30 days on this case.
Right. So you're not going to take no action right now, just leave that alone?
I was going to let you know that you're not going to get any credit for that case. So when you show up and you try to tell Judge Strobridge, Judge, I should have time on this case, you're not going to get any time on the felony case.
Right, I understand.
So if I don't take any action on your bonds, you're going to sit in jail on a misdemeanor charge and not on the felony charge.
Right, well, that's what I'm saying, so...
Okay. I just want to make sure you understand that.
Right,
So
right, so you're going to revoke the bond, so then I go to court February, right?
Yes. I say, I will take your 30 days. If you want to take 30 days, you can get out, that's fine. But I'm just telling you that you may not get out, later on because the judge is taking action on your case.
That's my advice.
Yeah, I'll just wait to go to court then. I won't take the 30 days.
Your Honor, we'll just ask for the bond on the new law violation and no objection to you revoking the out on bond charge.
All right. All right. So in February, you may resolve your case, all right? When you get to Judge Strobridge. All right, in 2021, MM460, the court's going to state the bonds as set at $250. That's a 2020 CF 9775AO. The court's going to revoke that bond based on the probable cause of a new law arrest while he's out on release in that case.
All be good time then, right?
Right. Yes, ma'am. It's setting a new bond at none.
Right. Right, okay. Is that negative?
No, I got the felony all of a sudden. I'm like, you tell me your name.
State your name.
Kanam Allen.
All right. All right, sir, you are here in 2021 CF 772AO on a charge of petty theft for 2 prior theft convictions. He's not on probation, right?
No, he's not on probation.
All right, I'm going to say the bonds is set. The condition of your bonds is that you do not return to the location where this incident occurred. Your bond is set at $2,000. I did find probable cause for your arrest. One point, the public defender to represent you in this case.
Oh, no.
All right, have a great day, sir.
I like to talk about the bond. Okay.
Ruben Wilkins,
Yes, sir.
is mental health.
All right. Point of public defender to represent Mr. Wilkins in the two cases that he's in front of the court for, 2021 CF 763, 2021 CF 764 AO. You all want to waive Mr. Wilkins' appearance?
Yes, Your Honor.
Judge, there's also 762.
Oh, sorry, 762, three cases, I apologize. Three cases, 762. You want to waive his appearance in all three cases, Mr. Thompson?
Yes, Your Honor.
All right. The court will waive his appearance. I did find probable cause in all three cases for his arrest. I'm going to state the bonds as set in this case. I'm going to order that he have no contact with any witnesses or victims in this case, and that he do not return to the scene of the location where this incident occurred.
And Your Honor, just for clarification, it's a $5,000 bond for the attempted carjacking?
Yes, sir.
Okay, thank you.
And all those conditions were on all three cases?
Correct.
Okay, thank you, Judge.
So all the conditions were All right. Tell your name, sir.
Brian Foley.
All right, Mr. Foley, you're here in 2021 MM 459 AO. Two charges one charge of trespass in an occupied structure. The second charge is possession of drug paraphernalia. Mr. Miller, do you have an offer for Mr. Foley?
Just 1 second, Your Honor. Adjudication, credit time served, Your Honor.
All right. Mr. Foley, the state of Florida is offering you adjudication, guilt, credit time served, and offer you'd like to accept today?
Yes, sir.
All right. Could you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You put your hand down. Tell me your name one more time.
Brian Foley.
Mr. Foley, you are here in 2021 MM 459 AO being charged with trespass in an occupied structure and possession of drug paraphernalia. Both of those charges are first-degree felonies. These are first-degree misdemeanors. I apologize. Both of those charges are punished by 1 year in the county jail and a $1,000 fine each. Do you understand that?
Yes, sir.
Did you want to enter a plea of guilty or no contest to these charges?
No contest.
Do you understand by entering a plea of no contest to these charges, you're giving up the right to have a trial?
Yes, sir.
You understand you're giving the right to have a court appoint an attorney to represent you at a trial?
Yes, sir.
Are you under the influence of any drugs or alcohol at this time?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
Okay. All right, I reviewed the charging affidavit in both your case. In your case, I do find a factual basis for the entering of your plea. Accept your plea of no contest at this time. I will give you credit for adjudicate you guilty of the charge, give you credit for the 2 days that you spent in the Orange County Jail. I'll impose court costs and cost of prosecution amount of $273. I ordered you not return to the location where this incident occurred. You understand that?
All right, thank you, sir.
All right, have a great day.
You too.
Oh, sir, do you work?
Work? No.
Yeah. Are you gonna get a job?
Yeah.
When are you gonna get a job?
Like, next week.
What you gonna be doing?
Construction.
All right. Or you pay these costs within 1 year of today's date. You understand that?
All right.
All right, have a great day. All right, man, can you tell me your name?
Paul Smith.
All right, Mr. Smith. You are here in 2021 MM 462 AO on a charge of violation of ordinance, I believe for panhandling, if I looked it up right. Mr. Miller, is there an offer for Mr. Smith?
Yes, Your Honor, it'd be adjudication, credit time served.
All right, Mr. Smith, the state of Florida is offering you an adjudication of guilt, credit time served, and an offer you'd like to accept today?
Yep.
All right. Can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You put your hand down, sir. Tell me your name one more time.
Paul Smith.
Mr. Smith, you are here in 2021 MM 462 AO on charge of violation of a county ordinance violation for panhandling. That is a second-degree misdemeanor. It's punishable by up to 60 days in the county jail and a $500 fine. Do you understand that?
Yeah.
Did you want to enter a plea of guilty or no contest to these charges?
No contest.
Do you understand by entering a plea of no contest, you give up the right to have a trial in this case?
Yeah.
You understand you give up the right to have the court appoint an attorney to represent you at a trial?
Yeah.
Are you under the influence of any drugs or alcohol at this time?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or forced you to enter this plea?
No.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation?
Yes.
I reviewed the charging affidavit in this case. I do find a factual basis for the entering of your plea. I'll adjudicate you guilty of the charge. I will give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. It's 273 still, right? It's 223 for the... 273. All right. So it's 273 and court costs and cost of prosecution.
I'm disabled.
Okay.
I got I can't pay it because I'm getting it right now. I had a triple bypass surgery back in June, and then I had angioplastic, and I was just playing the bongo drums, earn some money. You know, I wasn't like you know, I'm a street performer.
Yeah.
You know.
All right. I'll reduce your cost of judgment.
All right. Yeah, because I can't afford nothing right now. I'm not getting anything. Oh.
Yes, ma'am.
Yeah.
Have a great day, sir.
All right, you too.
All right. Can you tell me your name, sir?
John Anthony Sanchez, sir.
All right, Mr. Sanchez, you are here in 2020 MM 7288AO on warrant for your arrest for failure to appear. The judge in that case set your bonds at $1,000 on each of the counts for a total of $2,000. Have a great day, sir. And then I had Pollard bonded.
He bonded, Your Honor.
All right. Sorry. All right. Can you tell me your name, sir?
Anthony Michael Barrios.
All right, Mr. Barrios, you are here in 2021 CF 748AO on 2 counts, aggravated assault as to count 1, and burglary of conveyance with assault or battery therein. State, as to the burglary or conveyance with assault or battery therein, what are you asking me for?
I'm not going to argue for proof evident presumption grade, given that there's 4 people on scene. 2 people say conflicting, 1 says nothing, and the 3rd one says nothing actually happened. So I'm not going to proceed forward with that, Your Honor. So a bond is appropriate.
Even on his own statement? That's what I'm asking.
Well, the defendant said the guy was out of the truck. The guy said he was in the truck. The passenger of the truck never actually said anything.
Right.
And the friend admitted that a BB gun was thrown, but never discussed the fight. So there's no video, there's no photos, there's no corroborating evidence outside of that. So
I was just asking. All right, sir, I'm going to appoint a public defender to represent you in this case. As to the aggravated assault count, the court's going to set your bond in an amount of $2,500. As to the second count and the information, the court's going to set your bond in an amount of $5,000. You to have no contact with this victim. All right, so if the garbage comes gets picked up, stay inside.
I think they're probably going to change the route, but...
Sir, don't talk about your case.
I'm sorry.
Listen to me, follow my directions.
Yes, sir.
So if you put your garbage out, stay inside to the garbage man empties the garbage can, and then go back out and pick up your bin.
Yes, sir.
If you have contact with this victim again, you're going to be seeing me again, you're not going to be able to get out, all right?
Yes, sir.
All right, have a great day.
You too, God bless.
All right, can you tell me your name, ma'am?
Chastity Bencosme.
All right, Cosme, you are here in 2 matters. The first is 2021 CF 725AO for possession of MDMA or ecstasy. The court did find probable cause for your arrest as that charge. I'm going to state your bonds as set in the amount of $1,000. You were arrested for 2019 CF 3769 out of Osceola County for an out-of-county warrant. The judge set your bonds at none in the 2 charges that you are facing out there. So it will be held until your Osceola comes to pick you up here in a few days, all right? I'll appoint a public defender to represent you in this case.
So I'm going back over there.
So, ma'am, appoint a public defender to represent you, so you can contact them if you have any questions, all right? Have a great day.
Mr. Bryce?
Yes.
Behavior, Your Honor.
All right. All right, this is Mr. Bryce in 2021 CF 775AO. I'm going to appoint a public defender to represent him in that case. And Mr. Thompson, Ms. George, do you want to waive his appearance?
We'll waive, Your Honor.
I will waive Mr. Bryce's appearance at today's initial appearance. The court did read the charging affidavit, did find probable cause for his arrest in this case. The court's going to set bond in the amount of $2,500 as the bonds are already set, I think. It was $2,500 as count 1 and state the bond is $500 to count 2. The condition of his bonds that he did not return to the scene of this location and has no contact with his victim. And possesses no weapons or firearms. Okay. All right, ma'am, tell me your name.
Liz Brooks.
All right, Ms. Brooks, you are here in 2021 CF 184AO on a warrant, I believe. The judge had previously found probable cause for your arrest. The judge set your bonds at an amount of $2,500 each on each count of the warrant, which is 1, 2, 3, 4, 5. And then the charges are, fraudulent use of personal identification of a person over 6 years old, exploitation of an elderly or disabled person, scheme to defraud, theft of from a person 65 years or older, grant theft from a person 65 years or older, and credit card theft. Pre-trial, she was out on bond. If I can tell, she bonded out. Yes, she's out on bond. Yep, ma'am, you were out on bond in 2020 CF 2025AO. And in that case, the court is going to revoke your RR status. In that case, you'll be held at no bond until you can get in front of your judge for a bond hearing, based on the probable cause for your arrest in this case. So have a great day, ma'am. I'll appoint a public defender to represent you in all your cases. See? I'll about to throw this right down there. All right. Hello, sir. Tell me your name.
Cyrus Lamar Brown.
All right, Mr. Brown. 1 second here.
What did you say?
Mr. Brown, you were here in 2020 CF 1194AO for a warrant for a violation of your pretrial release conditions. The judge assigned that warrant, set your bond at none. Your bond remain at none until you can get in front of that judge for a bond hearing. I'm going to appoint a public defender to represent you in this case. So you have representation while you're in jail. You can speak to them about getting a bond hearing in front of the appropriate judge. You understand?
Yes.
All right, have a great day, sir. All right, good afternoon, sir. Can you tell me your name?
Lonnie Brummett.
All right, Mr. Brummett, you are here in 2020 CF 11776AL on a charge of failure to register as a sex offender. Court reviewed the judge assigned the warrant already found probable cause for your arrest. think, because you didn't follow the instructions of either Judge Wish or Judge Carter when they were here the last time. You are, the court's going to set your bonds as in this case 2020 CF 1176AO in the amount of $2,500. Condition your bonds that if you are released from the Orange County Jail, that you immediately report within 24 hours to the Orange County Sheriff's Office to register as a sex offender or a sexual predator.
He's saying he can't hear you.
I'm sorry.
I got you.
All right, Mr. Burnett, can you hear me now?
Yes, sir.
All right. Sir, you're here in 2020 CF 11776 AO on a charge of failure to register as a sex offender or sexual predator. The judge assigned your warrant and previously found probable cause for your arrest. The court's going to set your bond in this case in the amount of $2,500. And a condition of your bond is that when you meet upon your immediate release from the Orange County Jail, if and when that happens, you are to immediately register as a sex offender or sexual predator at the Orange County Sheriff's Office within 24 hours. You are out on bond in 2020 CF 4041 AO, and you're also out on bond in 2020 CF 9749 AO, and you're out on bond as well in 2019 CF 10013 AO. In all those cases, the court's going to revoke your bonds in those cases. I want to set new bonds in your cases, the amount of none, until you can get in front of the appropriate circuit judge to handle your cases. I want to appoint the public defender to represent you in all your cases while you're in custody. You have a great day, sir.
Sir, did you say you're revoking all my other bonds?
Yes, sir.
Could I ask you why?
Because you didn't follow the directions of the last time you were here. You were ordered to go and get registered, and you didn't. So now you have a new case where the court found probable cause, so your bonds are revoked at none.
All of them?
All of them, except the one that you were arrested on today. Your bond is $2,500.
So if I pay this bond, I won't get out?
Correct.
Thank you.
All right, good afternoon, sir. Can you tell me your name?
Burton Earl Burton.
All right. Mr. Burton, you are here you're here for failure to appear warrants in two cases. The first case is 2019 CF 11830 AO and 2018 CF 7864 AO. The judge assigned your capious bond, set your bond at none. Your bonds remain at none until you can get in front of the appropriate judge to address your case. I'm going to appoint a public defender while you're still in custody. You have a great day, sir.
I know, but can I please say something?
Your Honor, I advise my client against speaking, but he wants to speak with you.
Yes, Mr. Burton.
Sir, I had to see a doctor last week. The judge, they already got me going out on R&R.
Sir, the law does not allow me to modify capious bonds issued by another judge. That judge set your bond at none. So until you can work with your attorney from the public defender's office to get you in front of that judge, and you can explain to them whatever things that you need to do.
All right, thank you.
All right. Good afternoon, sir. Tell me your name.
Kendra Carter.
All right, Mr. Carter, you are here in a few matters. The first is 2021 CT 537 AO on a charge of driving while license suspended. In 2021 CF 761 AO, of course, you're being charged with possession of cocaine with intent to sell and deliver. As to those two counts, of course, I reviewed the charging affidavits in your cases. I found probable cause for your arrest in those cases. Does this DR, this is a writ? Do I have on my sheet?
Here, just
You took care of it?
support,
All right.
earlier.
You paid the purge?
Well, he went and saw the judge.
Oh, we saw the judge? All right. PTR, is this because of the charge?
I'm sorry.
The possession with intent, that's why you're gonna qualify?
It could qualify, yes.
Well, I'm saying, would he qualify? Because on my sheet it says no. But it says above average, maybe because of his history. I'm trying to figure out.
I mean, it's up to you, Your Honor, but due to that he has other legal restraints due to that writ warrant, we wouldn't qualify him.
Okay.
But if you wanted to place someone on pretrial, you could.
Mr. Carter, you got the money to pay your back child support?
I already pay, yes, sir. It's they lowered it. They lowered it to $50.
All right. And you gonna be able to pay that when you get out?
Yes, sir.
All right. On pretrial release in the 2 cases.
Thank you, sir.
I'm going to make a condition in your pretrial release that you are tested regularly for the consumption of illegal substances or alcohol. So you're gonna be drug tested. No drugs.
Yeah, I don't do drugs, sir.
Listen to me. No drugs or alcohol. Now possess or consume any. And you're gonna be drug tested.
Yes, sir.
All right.
Yes, sir.
You're driving in the state of Florida without a valid driver's license.
Yes, sir. I'm going to get my license.
All right.
Yes, sir.
Have a great day, sir.
You too.
All right, sir, tell me your name.
Edward Elmer, sir.
Mr. Elmer, you are here in 2020 CF 141020 AO on 2 charges. The first is fleeing or attempting to elude law enforcement with license signs activated and resistance officer without violence. Your bonds are set at court did find probable cause. Sorry. The judge signing your warrant found probable cause for your arrest already. It set your bonds at $3,500 and $1,000 as to count 2, resisting officer without violence. You're out on bond.
Yes, Your Honor. I was out on bond for a 2014 case.
CF 3340 AO case.
Your Honor.
Based on...
would the court have any objection to a no action in that case since it is a 2014 case and he hasn't been in trouble since?
Well, in those cases, the charges are trafficking in 28 grams or more, possession of a firearm by a convicted felon, possession of cannabis over 20 grams, possession of drug paraphernalia, driving license suspended, possession of ammo by a convicted felon.
And I understand that, but we see a lot of cases where they go maybe like 2 or 3 months before they pick up a new law violation. I mean, he hasn't reoffended since 2014. So just for that, I would just ask that the court just give him a second chance and not take any action on the out on bond charges.
I'm not going to do that. Well, based on the affidavit that I read in this case. This is the one where he...
Can I clarify something?
Go ahead, sir. Mr. Miller.
It looks like, according to our system, that 2014 case.
Yes.
actually pled in 2016. And in 2016, he was entered plea no contest. He got 3 years on one count, 6 years on another, a year and a year on the other ones, and the other one's credit time served. There was an appeal in that. There was a motion for new trial, appeal, a bunch of stuff denying, post-conviction. Eventually, in September of last year, the appeal, the fifth, affirmed in part, reversed in part, remanded with instructions, and so that has a status hearing on 4/14 in front of Judge Roach.
So he already served his time on the other case and he's out?
I was trying to look up the DOC
Put your hand down.
website.
Maybe PTR can help me out. Because I want to see if he's out on a appeals bond, which he couldn't get out on count one. Because he's not entitled to, he can't get an appeals bond on a trafficking case. So I was just trying to make sure he's not on bond.
Well, he is, there are bonds still active on the case as of September the 9th, 2019. There are bonds still active on the case.
So when they sent it back, did the judge then issue new bonds for his cases?
The mandate here, the state appealed an order granting in part the motion for ineffective assistance of counsel. He filed a cross appeal. The state voluntarily dismissed their appeal, leaving only the cross appeal to be resolved. So he argued that they didn't afford him the opportunity to accept a favorable plea deal because his attorney misadvised him of the maximum sentences. Of course, he was charged with the trafficking. The remainder of the charges would have been dropped or reduced to misdemeanors. The agreed upon sentence was 38.7 months, which would have included the min-man. He rejected that, proceeded to trial. This court PCA'd his convictions. He filed a 3850. We conclude the post-conviction court erred in its reliance on a case. Permitting a new trial in this case would not only needlessly squander something. Before releasing on bond after post-conviction evidentiary hearing, he had already served 39.5 months of his prior sentence. Under the trial court's order, his potential exposure would range in essence from 39.5, already served, up to life, yet prior to receiving ineffective assistance of counsel, he was already the receipt of a plea offer of 38.75 months, while the potential outcome ranged from acquittal to life. So they affirmed the portion of post-conviction order finding ineffective assistance of counsel and prejudice, but reversed the court's order as to the remedy granted, and then they sent it back for further consideration.
So it sounds like.
Would you have any objections to revoking the bonds and setting new ones?
Well, it sounds like the court erred in setting the bond. That's why I'm ultimately confused on what happened, because he's not entitled, what I can tell, in all intents and purposes, not kind of gleaming at the cases, is that when he appealed and the case went up, they PCA'd his conviction. He then filed a 33.850 for ineffective assistance of counsel. The court granted the ineffective assistance of counsel part of it, but the remedy was improper because he's not entitled to a bond as to that case. So technically, he still should be in custody of the Department of Corrections at this moment until his case is set for the status of hearing and the case needs to be heard again. So based on that mandate from the 5th DCA, the court's going to revoke his bonds as the 2014 case. Will set new bonds at none until he can get in front of that judge to correct that issue that they had.
All right, Your Honor, despite my legal advice, my client would like to address the court.
No disrespect, Your Honor. I just wanted to clear it up a little bit, what was going on with that. That was a 2014 case. I got sentenced to 6 years.
Correct.
I went to prison. I did half of the sentence. My attorney appealed it. I won the appeal. I won the 3850. I came back. When I came back,
sir, what I'm trying to tell you is that that part when you say you came back, That should never happen.
The judge overturned the conviction.
I know that. He didn't overturn your conviction. Sir, and even if so, and you were granted a new trial, let's say in reality that you were granted a brand new trial.
Right, everything started over.
Jury. The law says that because you were charged with trafficking and cocaine, that you're not entitled to what they call like in layman's terms, an appeals bond. So you were never entitled to release at any time, even after you won your appeal, until the case had finally came to a final conclusion. Either say drop the case, or you went back to trial and tried the case again. You understand?
Yes, sir.
So you should never be released.
But they reversed the whole conviction, and when I was in court, that was the issue. The
Even
judge
if
was
so. That's what I'm trying to say, and that's why the 50 CA told them they were wrong. Even if so,
They were
That's why I
wrong to
wanna
give
make
me a
sure that
bond?
you're clear about that. You should never been able to bond ever.
My lawyer just emailed me yesterday, said I got court in April to resolve the case for time served.
Correct, but you should never bond it. And that's the part where they return the case back. All right, so we'll get in front of your assigned judge. You probably get a quicker status hearing. Who's your attorney? You appoint
Matthew McLean.
Mr. McLean?
Yes, sir.
All right. So notify Mr. McLean that you're here with us and that you have a new case. I'm appointing the public defender's office to represent you on your new case, and I'll keep Mr. McLean on your case for your other case. All right?
All right.
All right. Have a great day, sir.
So you revoked my bond on my other case?
Yes, sir.
Thanks.
Other way. Good afternoon, sir. Have a great. How you doing? Can you tell me your name?
Your name?
My name is Boris Georov.
All right, Mr. Yola, you're here in 2021 CF 769AO on 2 charges. First count is possession of cocaine, and the second count is possession of drug paraphernalia. Because you're out on bond, I did find probable cause for your arrest in both cases. Would normally would have released you, but based on the fact that you were out on bond in a case in another county, 2020 CF 2702AO, the court's going to stay your bonds as set. I'm not taking any action as to the out of county case, but when we stay your bonds at 1,000 and 500 respectively.
Okay. So I can bond out?
Yes, sir. But similar kind of maybe come looking for you soon. All right, sir, can you tell me your name?
Daniel Green.
All right, Mr. Green, you are here in 2021 CF 759AO. First count is, you have 2 counts that you're arrested for. The first count is fleeing attempt to elude with lights and sirens, and no motor vehicle registration as the second count. The court did review the charging affidavit in this case. I did find probable cause for your arrest. I want to set bonds in your count 1 in amount of 2,500. As to the no motor vehicle registration, I'll set the bond amount of $150. I want to appoint a public defender to represent you in this case. Yes, ma'am.
Sir?
No. That's David Green.
Your Honor?
Yes, sir.
May I speak?
I'm appointing a public defender to represent you. You should talk to them first.
Your Honor, he does qualify for pretrial release, and he has no criminal history.
He just turned 18.
He just.
He's 20.
Yeah, he's 20 years old.
Oh, 20. That's what I thought. Also, my dates are all wrong.
Was there a bond? You said his grandmother paid a bond already? Are you showing anything? No? Oh.
There was no bond as to count 1, so not sure.
And though he is only 20 years old, I mean, he has no juvenile history. And this looks like this may be a, yeah, he has some juvenile arrests, but he has no convictions in his adult.
Then how do you fail to appear 2 years ago? I have 2 FTAs from April 2019.
Oh, yeah, I can take a look.
That was for my license.
So.
At least on pretrial release, Your Honor, he'll be able to be monitored by pretrial services then he won't be able to have any drugs or alcohol.
I'll do that. All right, Mr. Green, I'll release you on straight pretrial release. As to both your cases, a condition of your pretrial release that you are to not operate a motor vehicle without a valid driver's license. You are to not consume or possess any drugs or alcohol, including cannabis, without a valid prescription. Random drug testing at your expense.
Thank
All right, have a great day. All right, you lost David Green?
He bonded, Your Honor.
All right, David Green bonded. Did you want to take any action on that case right now, Mr. Miller?
On the cannabis one?
Yep. I don't know, you guys have been taking action, so I didn't know if that's the case you want to take action on.
I'll let downtown deal with it.
All right. All right, ma'am, tell me your name.
Karen Harrison.
All right, Ms. Harrison, you are here in 2021 CF 733AO, and also in 2021 CF 760. In 733, you're being charged or you're being arrested for dealing in stolen property and receiving money from a pawnbroker by false verification. The judge signing your warrant had all previously found probable cause for your arrest and set your bonds at $2,500 as to count one and $1,000 as to count two. You are in 2021 CF 760. You're arrested for possession of methamphetamine, possession of cocaine. Court did review the charging affidavit. I did find probable cause for your arrest in that case. So going to stay your bonds as set in that case, an amount of $1,000 each. You are out on bond in 2020 CF 12483AO, which may now be 2020 MM 588AA. In that case, the court is going to revoke your bonds in that case. Going to set new bonds at none until you can get into the front of the appropriate judge to handle that case. I appoint a public defender to represent you in this case. Oh, sorry. Sorry. You're right. Correct. I did see that. I did highlight it. Okay. No pawn or second-hand transaction is a condition of your bonds on the dealing in stolen property case. Or did you not return to the scene of the pawn shop or have contact with the victim in that case either as well?
Craig Hill, his behavior, Your Honor.
All right, let me sign this first. Today's the 19th, 20th, right? 20th. 20th. Today's 20th, right? Yeah. Oh, we got new orders. That's all right. Mr. Hill's behavior, I want to appoint the public defender to represent Mr. Hill. Mr. Hill is here on 2020 CF 15268AO. Charged with aggravated assault with deadly weapon, possession of a weapon or firearm by convicted felon, possession of a weapon during the commission of a felony.
We'll waive, Your Honor.
All right. The judge had previously found probable cause for his arrest in that case by the issuance of the arrest warrant. As to count one, the court's going to set his bond in the amount of $10,000. As to count two, the bonds will remain set as $2,000 and $2,000 as to count three. Keep the conditions of his bonds. He has no contact with the victim, has no return to the scene, no possession of weapons or firearms. He is out on bond in 2020 CF 9615AO. In that case, the court's going to revoke his bonds. They're going to set new bonds in the amount of none. I already appointed the public defender to represent him in all his cases. Good afternoon, ma'am. Tell me your name.
Kathy Lodge.
Ms. Lodge, you are here in 2021 CF 770AO on two counts. All possession of personal identification of another, 5 or more, and possession, sale, or delivery of a skimming device. court did review the charging affidavit in this case. I do find probable cause for your arrest in that matter. I'm going to set your bonds as account 1 in the amount of $2,000. I'm going to set your bonds as account 1 and account 2 in the amount of $1,000. I'm going to, in 2019, CF 16400AO. The court is going to revoke your bonds as to those charges, those cases, your release status. We're going to set new bonds at none. I'm going to appoint the public defender to represent you in all your cases. You can get in front of that judge and have a bond hearing if you'd like to get out. Have a great day, ma'am. Sir, can you tell me your name?
That's Matthew McCauley.
All right, Mr. McCauley, you are here in 2021 CF 480AO on a charge of failure to register as a sex offender or a sexual predator. The judge signing your warrant has already found probable cause for your arrest. We'll set your bond in the amount of this, in this case, the amount of $2,500. Making condition of your bond is within 24 hours of your release that you go to the Orange County Sheriff's Office to register. You understand that?
Yeah.
All right.
I understand.
Don't forget to go register because I'll see you back in very shortly. You understand that?
Yeah, I'll take care of it.
All right. Have a great day.
Yep. Thanks a lot.
All right, ma'am. Tell me your name. Tell me your name.
Brianna Nicholson.
All right, Ms. Nicholson, you are here in two matters. The first case is 2021 MO 114AO on a charge of disorderly conduct. You're also arrested in 2021 CF 772AO on 2 counts, battery on a law enforcement officer and resisting officer with violence. Mr. Miller, do you want to resolve the sitting ordinance case? Or is it?
Your Honor, I would advise the client not to accept the plea in this case. It seems like she has zero criminal history, like nothing. This appears to even be her first arrest. As a matter of fact, if the charges weren't valid, I would ask for an RR in her case.
So pre-trial, does the charge not qualify? That's what it is?
No, we didn't get a chance to interview her.
That's what it was.
Yeah.
All right, so I'll do this. Ma'am, as to your cases, I'll do this. I will set bonds in the amount of $100 as to the MO case. I'll set bonds in the amount of $1,000 and $1,000 each as to your felony case. Or an alternative, if you do qualify for pre-trial release, I will grant you straight pre-trial release with the caveat that you do not return to the scene, that you have no contact with let's see, what's her name?
Israel Lewis.
Say again? Lewis, what was the first name?
Israel.
Israel Lewis. So no contact with Israel Lewis, no return to the scene where this happened. You understand?
Yes. Can I ask a question?
Talk to your attorneys first. I'll appoint a public defender to represent you in your cases.
Your Honor, can you see if the defendant resides out of state? And if so, are you allowing her to return out of state while she's on pretrial release if she's granted
Ma'am,
it?
where are you residing? Are you here in Central Florida now, or are you?
I live in Detroit, Michigan.
You live in Detroit, Michigan? All right. Are you going? You want to return there when you release, or are you going to stay around here?
I want to go home.
All right, I'll allow her to go home. But you got to come back for your court dates.
Okay.
That's a long bus ride from Michigan all the way to Florida. You understand me? You're not even paying for flights, so you're going to ride a bus from jail to jail if you don't show up for court. You understand that?
Okay.
All right.
What am I doing? You're done. Okay. Thank you.
Yes, ma'am.
Singer. His behavior, Your Honor.
No Singer?
Yeah.
Noah Singer? You said way better than I did. Noah Singer. He's in here in case 2021 CF774AO. The appointed public defender represent him in that case. Do you all want to waive his appearance?
We'll waive, Your Honor.
All right, we're waiving Mr. Noah Singer. Initial appearance today. He's being charged with a crime of petty theft and 2 prior theft convictions. The court did find probable cause for his arrest, but state. Do you think the court should take any action? That's his out on bond case.
Sorry, Judge?
Do you think I should take any action? His out on bond case.
Even the court's discretion, no position, Your Honor.
I'm a little concerned that he's drinking Listerine.
To each his own.
All right. I'll leave the bonds as set in this case. I won't take any action as to his out on bond case. He's having enough issues there.
Hello.
Hold on, can you tell me your name, ma'am?
Sir?
Can you tell me your name?
Jamie Pelletier.
Ms. Pilfer, you are here in 2021 CF 768 on 2 counts. The first count is possession of cocaine, second count is possession of methamphetamine. I did find probable cause after reviewing the charging affidavit for your arrest. I'll do this. I'm going to stay your bonds as set in my 1,000. The condition that you do not possess any drugs or alcohol, or I'll straight pretrial release you if you qualify.
No, Your Honor, she doesn't qualify.
Okay, because you didn't interview her.
She has two open Seminole County cases.
Okay, that was her updated?
I'm sorry?
That was an updated sheet?
You got 2 pages?
No, I got 2 pages, but.
On the
Oh, okay, I
page.
got it. All right, ma'am. Yep, you do have some Seminole County cases, but your bonds are $2,000. In this case, these cases, Seminole County may be coming to pick you up soon, so.
All right,
be aware
thank you.
of that. All right, sir, tell me your name.
Brandon Pretty.
Mr. Pretty, you are here in 2021 CF 749AO on charge of failure to register as a sex offender. Judge, issuing your warrant did find probable cause for your arrest. I want to set your bonds in the amount of $3,500. Condition your bond that upon your release from this Orange County jail that you go to the Orange County Sheriff's Office and register within 24 hours. Pretrial says he's on state probation out of this county. They don't have a case number. Time to look it up.
Yes, it's out of Orange.
You have a case number?
I'm sorry?
You have a case number? Mr. Miller, can you find me the case number for Mr. Pretty that he's out on probation for?
Yes, sure. According to the DOC website, it appears to be 108717. Let me just verify that. 2010 CF 8717. 2010 CF 8717. Yeah, 2010 CF 8717. All He's on 15 years of sex offender probation.
All right, sir. Can you tell what the charge was in that?
In that case, the charges were, it was disposed of, pled as a F2 attempted lewd or lascivious, and he was adjudicated 5 years with 15 years of probation.
Mr. Purdy, you were out on probation when this incident happened in 2010, CF 8717 AO. The court finding probable cause that you committed a new law offense. We're going to do an on-view violation of your probation in this case. In that case, I want to set a bond at none. You are a violent felony offender of special concern, sir. You are not entitled to release until your case is resolved. You understand that?
Okay.
All right, we're done.
Thank you.
All right, sir, tell me your name.
Christopher Rosa Flores. I was just telling the officer that I don't see my attorney here.
Your attorney?
Yeah.
Who's your attorney?
Ken Lewis.
Ken Lewis? Did you hire Mr. Lewis already? Paid him money and signed a contract?
Yeah.
For which? For the underlying case?
VOP.
For the VOP? You have a note?
I'm gonna check. I don't have a note.
Mr. Miller, can you do a little research for me while we're doing that? He's on probation for a vehicular homicide. I'm not sure if that's a makes him a VFOS or sure or not.
We don't have anything.
Not anything?
He does have Ken Lewis on that case. I don't know if that was previous or now. And then, what's the concern?
I didn't know if he was a violent felony of special concern based on the vehicular homicide conviction.
One moment.
He's not, Your Honor.
Well, I was gonna make sure. No, I was gonna make sure you wasn't in that category of offense. All right. Mr. Rosa Flores, your attorney's not here, but I want to go forward with your pre-trial. Your entitled to representation at this hearing, but you're not entitled to a bond on this case because the judge set the bond at none for your 2015 CF 4653 violation of community control. You may want to reach out to your bondsman in your 2021 MM6 case because you're still going to be sitting in jail without getting any credit because you're out on bond in that case.
What was? I'm sorry, Your Honor. What was
you got
that
a
again?
violation of community control warrant here for your violation of community control. Your bond is set at none. It looks like you bonded out on your new law case, so you're not going to get any credit time served for your new law case while you're sitting in jail. So you may want to reach out to Mr. Lewis or your bondsman and figure that out, okay? All right, have a great day. All right. You guys can start. Tell me your name.
Arias Salazar.
I can't hear you.
Arias Salazar.
All right, Mr. Salazar, you're here in 2021 CF 767 AO and 735 AO. The court's reviewed your charging affidavits in both your cases. I did find probable cause for both offenses of possession of methamphetamine and grand theft motor vehicle. One of your bonds is set in $1,000 as to possession of methamphetamine and $2,500 as to the grand theft motor vehicle case. condition of bond, you not return to the location where this happened, and you have no contact with the victim. Do you understand? All right, have a great day, sir. Appointed public defender to represent you.
Your Honor, we're asking if you could lower the bonds, if you'd be willing to lower the bonds on either of his charges.
No, his last conviction was from last month, so no. Have a great day, sir. Sir, can you tell me your name?
Marvin James Green, Jr.
All right, Mr. Green, you are here in 2018 CF 7283AO over violation of probation warrant. The judge in that case set your bond at none for your violation of probation. Your bond will remain at none until you can get in front of that judge. I appoint a public defender to represent you in this case, and you can possibly get a bond hearing if that judge is willing to give you a bond. Have a great day, sir.
Your Honor, he should have another case, I believe.
I'm Mr. Green.
Yes.
Oh, sorry, you are correct. Sir, you're also here in 2021 CF 721 with aggravated assault with a firearm. Court in that case is going to set your bond in the amount of $10,000. I'm going to make condition of your bond. You have no contact with the victim, no return to the scene, no weapons, no firearms. Any weapons or firearms you have need to be returned over to law enforcement within 24 hours of your release. All right. You appointed public defender to represent him in that case as well. Have a great day, sir.
Thank you.
Good afternoon, ma'am. Can you tell me your name?
Nicole Nobles.
Ms. Nobles, you are here in 2018 CF 6880AO for a violation of probation. The judge in that case set your bond at no bond. I'll put the public defender to represent you in that case, and they will get you in front of that judge to get you a bond here as soon as they can.
Okay.
Have a great day. Those on the way. All right. Good afternoon, ma'am. Can you tell me your name?
Annie Goodwin.
Ms. Goodwin, you are here on an out-of-county warrant in 2020 CF 4800, I believe, Brevard, right? Yeah, from Brevard County. The judge issuing the warrant set your bond at none. The bond will remain at none until you're transported to Brevard County. You understand? Have a great day.
Thank you.
I appoint a public defender to represent you in that case while you're here in our custody. So I'm appointing the public defender to represent you while you're here in my custody, okay?
Okay.
All right, have a great day, man. All right. Good afternoon, sir. Can you tell me your name?
Anthony Hall.
Mr. Hall, you are here on an out-of-county warrant, I believe from Gaston County. Yes, from Gaston County.
Yes, sir.
On 9 counts, the judge set your bonds at $1,000 each on each of those counts, for a total of $9,000. You can bond out, you'll be great, but you can't bond out, you'll be transported to Gaston County. Say again?
I had already did 6 months.
I
mean, not 6 months, but
I'll appoint a public defender to represent you. If there's an issue, you can talk to your attorney about it, and maybe we can get it resolved. Good afternoon, ma'am. Can you tell me your name?
Ramaya Johnson.
Ms. Johnson, you're here in 2 matters. The first case is 2021 CF 580 for charge of grand theft motor vehicle. Court then found probable cause for your arrest. I'm sorry, apologize. You're here for out of county warrant. We already did the grand theft motor vehicle the other day. You're here on 2 warrants, one from Seminole County for possession of methamphetamine. The judge in that case set your bond at none. You have another warrant, I believe also from Seminole County for a violation of probation. The court set your bond at none in that warrant. Your bonds remain at none until Seminole County comes to pick you up. I appoint a public defender to represent you in this case. Have a great day, ma'am. I had 2 sheets.
That's the same thing. It's only
okay.
one.
There's only one. I'm sorry. I apologize. It's only one, right? Yeah. Somebody gave me 2 sheets, so I thought it was 2 cases. But I guess it's just one case for violation of probation from Seminole County.
I did that already.
You did the grand theft case the other day, and I think this is the warrant from Seminole County for violation of probation.